The Supreme Court has upheld insolvency law in entirety. They have upheld the ban on promoters to bid under the bankruptcy law, and that's a big one, and I think would have a meaningful influence, as I would given to understand, on the whole SR Steel issue. But we'll kind of get a quick reactions in to understand what the road looks like ahead, because a lot of cases will come under the bankruptcy law. It's been seen and touted as the most meaningful reform, the reform of high impact when it comes to seeing the transition in corporate India from being entirely unregulated when it comes to an exit clause when a business goes kaput, to having a structure that can help in the whole insolvency and bankruptcy process at a time when a business can't stand on its own or cannot continue to hold on its own. So that's something that would be of meaningful change, like I pointed out. Supreme Court is also saying that founders can't bid under the bankruptcy process, and like I said, there's so many cases which are right now hanging in the middle with regards to this particular clause, where promoters are not willing to let go of their businesses. There's much to and fro with regards to negotiations on at what price do these businesses get sold. There's a bit of a prestige issue attached to selling off businesses that are family owned. And so I think the Supreme Court's clarification on that front will go a long way in adding speed to the process of resolution when it comes to some of these disputed accounts. And like I said, we'll get in more reactions, but the Supreme Court has upheld the bankruptcy law in its complete entirety and has upheld also the ban on promoters to bid under the bankruptcy law. I believe Sandeep Parekh joins in with a quick reaction. This perhaps would be seen by many on the street as the right way forward, because one would imagine that promoters have a bit of a prestige issue when letting go of their businesses. So this may in fact just help in adding speed to a process with regards to resolution of bad accounts or bad businesses. Sandeep?
Yes, absolutely. I think this puts a quietus to the whole episode of whether their particular provisions are invalid, etc. So I think we have upheld the entire Act and the specific provisions which were amended later with respect to barring of promoters. So I think it's a good move forward, and I think this also kind of settles the case for creative destruction, which is kind of the basis of insolvency code. That whatever can't be, where the promoters have failed, sell whatever business is remaining, and let the new process of regeneration start after that.
The case that comes to mind is really the Ruiyas who are battling to keep SR Steel within the SR Group fold. This pretty much makes it amply clear that the process of insolvency and bankruptcy will go ahead and that SR Steel will be sold. Sandeep?
Yes. Yeah, it seems like that. As from summary, it seems they've upheld every single provision, so which means that, whatever has been the stance of the government till now has been accepted. And I think anybody who's kind of put in personal guarantees, etc., will obviously be in some trouble, because, it's essentially not just the corporate assets, but also the so-called house of the promoter also gets a first day, because they often give personal guarantees in cases like this.
Sandeep, yes, and they've rejected, the Supreme Court has rejected the operational creditors' challenge to IBC, rejecting pleas seeking changes in the Insolvency and Bankruptcy Code. We spoke about the very high-profile case as well with SR Steel. What exactly do you believe, these new details bring about? Because a game-changing reform, so to speak, for a lot of, Indian corporates, as we've been talking about as well. How do you believe that now with the Supreme Court upholding the IBC in its entirety, upholding the ban on the promoter bid under the bankruptcy law, what kind of a precedent does it set for even other cases?
So I think it has a huge beneficial impact on the economy. In the past regime, we used to take 10 to 15 years for a company to be wound up. Number two, NPAs used to linger for years and decades at times. So, and that will hopefully happen in a period of 1 year or less. And finally, I think, as I said, the creative destruction is very important for a healthy economy. You need the deadwood to be cut, and you want new shoots of growth to come out of the same space. I think this will be huge for the economy itself, and it'll be good for the banking system because it allows them to kind of move forward and not linger over bad debts.
Yeah, okay. In fact, Maithili Busnurmat also joins in, Sandeep. Very important insights that you're bringing to the table. Maithili, thanks very much for joining in with your perspective. Let me just update you on the story. So the Supreme Court has upheld the Insolvency and Bankruptcy Code in entirety. They have rejected pleas seeking changes to the IBC, are saying founders and promoters can't bid under the bankruptcy process, pretty much paving the way forward for disputed accounts like Essar Steel. I mean, essentially not allowing the family to now come in the way.
Well, yes, it is certainly good that the Supreme Court has upheld the constitutional validity of the IBC, but I'm not so sure that upholding it in its entirety, including Section 29A, is a very wise thing. Because Section 29A, which was brought in more, I think, to assuage political issues really about the promoters and anybody related to the promoters being able to buy back an NPA at a very low discounted price, it was far too all-encompassing. It virtually ruled out anybody who had even the remotest of relationships with the promoters, regardless of whether the promoters themselves were directly guilty of fraud or whether it was just because of circumstances, extraneous circumstances, that the account had become an NPA. Contrast this with what is happening in the U.S., where Sears, a company which is once upon a time, almost synonymous with with discounted sales, and it was effectively the Walmart of those days, and even now employs more than 50,000 people. So Sears is going into liquidation, and the promoter, the erstwhile promoter, is being allowed to buy it back, maybe at a discounted price, provided the creditors are satisfied with the deal that he's offering. This is a so sensible and pragmatic, I think, we are approaching it, rather than to have the very all-encompassing nature of Section 29A. Yes, wherever the promoter was guilty of fraud, wherever the promoter has deliberately run the company to the ground, there would be a case to rule him out. But to have the very wide kind of exclusions which are there presently under Section 29A, that I think needed a rethink. The simple reason that it's going to do far more damage to the economy than the benefit in terms of ensuring speedy resolution of NPAs.
That's an important point, Maithili. You're essentially saying that if they have a good case, why not give the promoters a second chance? Nilang Desai, partner AZB, also joins in with his perspective. Nilang, how do you look at the Supreme Court's verdict?
Well, I mean, as an IBC practitioner, I'm obviously glad that the Supreme Court also thinks that the IBC is constitutionally sound. I think concerns about 29A need to be resolved in a different manner. I don't think the striking down of provisions of the IBC would have helped, because that would have just caused pandemonium in all the processes that are ongoing.
All right. Nilang, give us a sense as to what this could mean in the long haul as well, not lingering over bad debts and clearly setting a precedent for other cases as well, along with the high-profile Essar Steel one.
I mean, what it means is there's been a lot of talk recently about how the IBC is becoming weaker, and truant promoters are getting rid of the fear of the IBC, etc., etc. So I think this judgment serves as a reminder that the IBC is here to stay, that the impact it's had on the corporate credit culture is here to stay. And, those creditors who need to use it will be able to use it. And those debtors who are shying away from, making payments where they can and they should, need to fear it and need to fix their ways.
Very quickly, how do you see the Essar Steel story play out from here, given this verdict?
So I haven't had a chance to read the verdict, but I mean, to the extent that the IBC is intact, effectively what it means is that to the extent there's any challenge on the IBC in that litigation process, that's now ruled out. But there are other, obviously, legal contentions to be resolved in the Essar Steel dispute, which I think are not, to my mind, affected as yet by this Supreme Court judgment.
Right, judgment serving as a reminder that corporate credit culture is here to stay. With that, Nilang, Sandeep, Maithili, thanks much for taking time out and joining in, giving us a view as to what exactly this news means, the breaking news right now that the Supreme Court has upheld the IBC in its entirety. Founders cannot bid on